morning. Thank you. Please be seated. This is the time set for oral argument in 1 CV17 0631, Spencer versus ASHER. Each side is allotted 20 minutes for argument. Appellant, you may reserve a portion of that time for rebuttal, but we ask that you please keep track of your own time on using the podium clock for any time for rebuttal. Out of respect for counsel and the court, I ask that those in attendance please make sure your cell phones are off or on vibrate. Counsel, we have read the briefs. We've conferenced this case just this morning, and we encourage you to keep that in mind when you present your oral argument. These proceedings are being recorded and will be posted to YouTube. So before you begin your argument, please state your name and the party you represent. With that, we will start with counsel for appellant.
Thank you and good morning, Your Honors. Michael Ork on behalf of appellant Alicia Asher, and she's with us in the courtroom today. And if it pleases the court, I would like to reserve approximately 5 minutes for rebuttal. And certainly if the court has any questions, I'd be happy to address those as well. This is a very simple breach of contract case, and yet the party that breached under the agreement was not only excused from performance, but the trial court awarded approximately $100,000 in a judgment against the non-breaching party in terms of monetary damages, statutory damages, attorney's fees, and costs. And that's why we bring this appeal today. The factual background, Your Honors, is that in early 2016, the appellee, Ms. Spencer, listed her property for sale as it was a for sale by owner property. The Ms. Spencer as the seller and my client, Ms. Asher, as the buyer, entered into some negotiations to purchase the property through a seller carryback agreement. And because this was a for sale by owner property, real estate licensees were not used to document the transaction, and that obviously saved the seller ordinary real estate commissions. Ms. Spencer, as the seller, assembled a set of contractual documents that she had prepared. According to Ms. Spencer, she had those documents reviewed by her counsel. She then provided the documents to Ms. Asher for execution. The salient terms of the purchase contract was that the total purchase price would be $275,000. Ms. Asher would make an immediate down payment of just over $76,000. Ms. Asher would thereafter make monthly payments of approximately $1,400 a month, and there was a balloon payment in January of 2019. The contract also provided that Ms. Spencer, as the seller, would deliver possession to Ms. Asher on or before March 15th of 2016, and time was of the essence under the agreement.
Let me clarify. Does not the agreement say time is of the essence as to purchaser? I thought that the agreement says that. And does that make a difference? Can you impute that time is of the essence to the buyer if it just says or to the seller, I mean?
Well, a couple of points about that, Judge. Number one is that the contract was prepared by the seller, and so any ambiguity should be.
But is that ambiguous? I mean, it says time is. But assume it does not apply. Right. Was your client still entitled to possession on the 15th?
Absolutely, Judge.
At midnight.
Absolutely,
or the
Judge.
16th.
The time of the essence provision, whether that runs to both parties or just one, doesn't negate her contractual obligation, the seller's contractual obligation to deliver possession.
Your contention is that that's a material breach.
Absolutely, absolutely.
Within like the next day? What as of when is it a material breach? Can you give me a date?
I would say as of the day it was due. So one of the most important terms and obligations that the seller owed was to deliver possession of the property in the condition that it was in. So my client, as the buyer, her performance obligations were financial. She had to make a down payment in excess of $76,000 paid every month. The seller's obligation, primary obligation, was to deliver possession. And that was breached on March 15th when she didn't deliver possession. To the extent that the trial court should have set a date for what would be material, it's a kind of a fact question that was improper for the court.
Understood. And on that note, is it your basic contention here from reading your brief, because in the conclusion it seems to me that you're requesting that we vacate, if we agree with one or more of your arguments, that we vacate the judgment and remand for further proceedings. Is that so? I read that but I also read your brief as suggesting that the court erred in not granting summary or denying your motion for summary judgment on breach. So, are you asking for breach for judgment as a matter of law on your counterclaim?
No, we're asking that it be remanded for further proceedings.
For further proceedings, okay.
And that's because Ms. Asher filed a counterclaim. And to explain, she had a tenant lined up for this property, Judge.
I understand.
And so she was forced to breach that lease.
On that note, let's explore that a little further. I note that there's several things in the judgment, I think as opposing counsel pointed out in the answering brief, that quite frankly are not addressed in your briefing. For example, the trespass, the finding of trespass and associated damages. What are we to take of that? If we're to find that there's a question of fact as to anticipatory breach, what flows from that? How does it affect? Does it affect all the judgment, part of the judgment? How would that possibly affect the trespass finding that the court made in the judgment, but seemingly not in the summary judgment ruling?
Well, our position, Judge, is that the trespass is irrelevant to the breach findings by the trial court. So we didn't appeal, as Your Honor notes in the briefing, the trespass findings, but the trial court could still determine on remand that Ms. Asher did not anticipatory repudiate through a positive and unequivocal statement that she wouldn't perform. She performed. The trial court could make that finding, reject the plaintiff's claims for anticipatory repudiation and breach of implied covenant, and also find that Ms. Spencer, the seller, was in breach of contract, which would negate and unwind the judgment for money damages and entitle Ms. Asher to prove up her claim for damages.
Why didn't you appeal that judgment? I understand your argument, which is there is no trespass unless you find the anticipatory breach. Because if there wasn't an anticipatory breach, then contractually she may have the right, subject to whatever the court ultimately finds, to take possession. But why didn't you appeal that part of the judgment?
Well, to be candid with you, Judge, we were focused on the primary issues here, and the damages that would arise from a trespass are very limited in nature.
But the court said in its judgment it's $16,000. Now, for the life of me, I don't know where that came from, and I plan on asking opposing counsel that question. But to me, it sounds like you're almost conceding, or I need to know if you're conceding whether that $16,000 and trespass are ironclad and they stay part of the judgment.
No, though the trespass is a separate issue from the $16,000. My understanding of the $16,000 in damages was effectively lost rent that was awarded to Ms. Spencer based on a period of time in which she did not have possession. Ms. Asher did, first she tried to obtain possession through a forcible entertainer action, which was unsuccessful. And then she effected self-help remedies to obtain possession. And that's where the $16,000 in damages arises out. On remand, if the court determines that Ms. Spencer breached by not delivering possession, then our position is that all of that gets unwound. The court should have found at the time of March 15th or the 16th that Ms. Spencer was in possession, Ms. Asher was entitled to possession, and that it wasn't a trespass thereafter. And so it's almost sequential in that sense. And the damages all stemmed out of the fact that my client did not have possession to which she was contractually entitled.
So your position then now is that if the breach part is unwound, everything that's built upon that has to, by definition, be unwound as well.
That's correct, because at that point, and this is in several of the cases that we've cited, my client had an election of remedies. She could have done several different things. She could have sued for a specific performance. She could have sued for money damages. But she had a number of different options available to her following the breach by the seller failing to give possession. And so, yeah, once the court determined incorrectly that my client anticipatorily repudiated and that Ms. Spencer did not breach, we would take it back to that point upon remand. So to touch on a couple of the issues, and obviously this is a de novo review, This was a trial court granting summary judgment on it, what it deemed it an issue of law, and of course the evidence should be deemed or viewed in the light most favorable to Ms. ASHER. The court's finding with respect to anticipatory repudiation was clearly an error, even though that's not the standard. Anticipatory repudiation requires a positive and unequivocal manifestation that a party will not perform when the time for performance is due. And there's simply no evidence in this record that Ms. ASHER ever made a statement or any action whatsoever that could be construed as a positive and unequivocal statement that she would not perform. In fact, as I mentioned before, her performance obligations were monetary. She had to pay $76,000 upon execution. She had to pay approximately $1,400 per month thereafter. She paid that upon execution. She paid in March, April, and every month until the conclusion of the lawsuit when the court ordered rescission in September of 2017. So there's simply nothing in the record, and there's nothing that appellees point to that would be an unequivocal statement that my client would not perform. And the facts show that my client did in fact perform. Again, she made every single payment, and all of her actions at that time, including attempting self-help, including the forcible entry and detainer, were in furtherance of performance. She wasn't trying to back out of the contract. She wasn't trying to rescind. She was trying to enforce her contractual rights by obtaining possession because she'd been paying all along and she was going to continue to pay. The breach of implied covenant claim, this was a claim that required proof that Ms. ASHER denied some contractual benefit of the bargain to Ms. Spencer and caused harm to her. And I'll note the trial court's order in granting summary judgment in favor of Ms. Spencer held that Ms. ASHER breached by quote-unquote coercing Spencer into signing the assignment document and then attempting to use that document to feign the benefit of the bargain. And it's important that I explain what that assignment document was and what it wasn't. The assignment document was part of the contract package that Ms. Spencer advised my client that was reviewed by her attorney. It was prepared and provided by Ms. Spencer to Ms. ASHER to sign. So there was simply no evidence of coercion. We're talking about a situation in which the seller provides contract documents for the buyer to execute. The buyer executes. That's not coercion, and there's no evidence in the record.
The trial court find coercive then in the record?
But there's no evidence to support, Judge. It was a conclusory statement in the order that I find that it was coercion on the part of Ms. ASHER. I believe that, and certainly Appellee's counsel can address this issue, I think that at the trial court level, the seller introduced some evidence that would go to the relative bargaining power or experience of the parties, which is clearly an issue of fact that was improper to make this determination. And to explain a little bit further, Ms. ASHER owned several other rental properties. This was going to be a rental property. She had previously lived in the area across the street, but she was intending to buy this as a rental property.
The problem with the assignment is that it would purport to make her your client both the payee and the payor, correct?
Correct.
Did she ever, is there anything in the record to suggest that she ever tried to follow through on that? In other words, pay the money into some manner that she would be the one receiving it as well?
And that's a great point. And no, there's nothing in the record. The assignment document was never acted upon by any party in this case. That document was in effect between April 2nd of 2016 and approximately March 18th of 2016, and neither my client nor anybody else took any action or refrained from action on the basis of that document.
She did record it, though, and she did use it in justice court.
Well, to be clear, my apologies, Your Honor. To be clear, and this is in an exhibit to the complaint, there's a statement attributable to Ms. Spencer that Ms. Spencer recorded it. And I think the testimony was that both of them were there present together when it was recorded. But the only way that my client could have used that document, and effectively it would have merged her rights as a buyer and a seller, and she could have paid herself or basically take title without making any further payments under the agreement. And she didn't do that. Never once did she say, ha, I got you to sign that document. I don't have to pay anymore. She did pay, and the record is uncontroverted in that regard. After the document was executed, she made every single timely monthly payment thereafter. Now, with respect to the statement that was made at the FED, or forcible entry and detainer, It was simply a vague statement that my client made, and the statement was simply that she, quote unquote, held rights to a contract. But that is not an unequivocal representation that she wouldn't pay. I don't know what it means exactly. But I will tell you that she was a pro se litigant appearing in that forcible entry and detainer against a very experienced attorney, and that was the statement she made at the time, that she held rights to a contract. That is not unequivocal that she wouldn't pay. If it was her intention after that document was executed to avoid her performance obligations, she wouldn't have paid.
She continued to pay after making that statement.
Absolutely. She paid the $76,000 upon execution, and she paid every single month thereafter, even though she didn't have possession of the property. And that's, and again, that highlights her her performance obligations were financial. She had to pay. The seller's primary performance obligation was to deliver possession. She never did that. And that dovetails into why the court erred in rejecting my client's counterclaim for breach based on failure to give possession. And unless Your Honors have any additional questions, I'd like to reserve the rest of my time.
Thank you, counsel.
Thank you.
Good morning, Your Honors. John Lohr and Evan Schechter on behalf of the appellee, Nancy Spencer, who is also in the courtroom behind me. By way of a brief summary, the parties just have very different views of this case, but that does not create a factual issue that requires this court to reverse the trial court's decision. It cannot be disputed that appellant used an assignment of the contract in an attempt to eliminate Nancy's rights under the contract.
How did she use that, and when? When's the first time that the very first date that she used that assignment to interfere with the contract?
We need to look at what the impact of the assignment does. First of all, it transfers my client's rights as the seller to the buyer.
Your client drafted and created the assignment.
My client obtained the document from LegalZoom. Okay, she presented it. She presented a packet of documents to Ms. ASHER. The contract itself was signed on February 29th. 3 days later, Ms. ASHER calls my client and says, hey, we need to go record these documents. She has my client come to where they recorded the document, which I believe was the library, and she has my client sign, which was in the original packet of information, the assignment. So the assignment was not signed in conjunction with the contract. It was signed 3 days later on March 2nd. And this document here, which counsel completely ignored in his briefs, the kiosk sales receipt for the Maricopa County Recorder's Office, shows you who was responsible for recording the assignment.
When your client executed the affidavit of Scrivener's there, she said, quote, I recorded the document I recorded.
But you got to go backwards.
Well, okay. Does that not in itself right there create a factual issue between who recorded the document?
It doesn't, because you have to look at the timing of when that was signed, and you have to look at the events of what happened prior to that. So
why would she acknowledge recording the document if she didn't do it?
I'll explain.
Okay.
So immediately after recording the assignment, my client came back to me because we were having problems right away with Ms. ASHER. Ms. ASHER did not submit the proper documentations to set up the third-party servicer with Westar. She did not provide a proper address in the contract for notice if she was in breach. She was late on the first two payments. We immediately noticed the error, and we.
Wait, was she late, or was it just the problems with the servicer?
I'm not sure exactly.
Okay.
So
the servicer receipted the check in on the 16th of March.
But it wasn't paid to my client because of the issues with the.
It wasn't supposed to be.
Oh.
She agreed that it would be paid to the servicer.
So, but these are the issues that we were confronted with, and we didn't know that, and we sent notices of default right in the very beginning. And
back up on that. If she's really late on the rent, weren't you obligated to comply with the notice to cure provisions?
And we did.
14 days for right then.
Well, no, because she didn't have possession. So
for rent.
It wasn't rent.
For the payment. Okay,
yeah.
For the first payment, why wouldn't you? Okay.
We did.
It wasn't done. You concede it was not done.
But we did. We did.
March.
We sent written notices both in March and in April that she was late on our payments. We complied with the notice provisions. That's in the motion for summary judgment.
The record of the
Excuse me?
where that is, the 15-day letter or 14-day letter
Or we can find them, but
in March.
yeah, it's attached to the declaration of my client that was in support of the statement of facts in the motion for summary judgment.
Fine. But
both of them were there.
can you address? Because I think what I'm struggling with is the 15th,
Sure.
the failure to deliver possession.
Okay. So, again, we have to look at the facts of the case. Look at what was going on at that time.
I know. The problem that you'll have to straighten me out. It's how all of this becomes a question of law and not a factual issue. But
Again,
go ahead.
we first have to focus on the assignment itself. The assignment itself did three things. First of all, it eliminated the contractual requirement for my client's no longer the seller anymore. The Ms. Asher is the buyer and the seller. Second, there's a provision in the contract that requires the title to the property to be transferred at the end of the 3-year period. Because Ms. Asher was now the buyer and the seller, she could transfer title to herself right away. And in fact, by recording the document, that's what she was alerting third parties to, that I now hold the power of both the buyer and the seller. I own the property. I can transfer the property to anyone. Third, by saying that she's the buyer and the seller, she's basically saying, I don't have to pay you anymore.
But she kept paying.
But she kept paying.
She paid, but you have to look at what we were doing at the time. We were telling her, look, you want possession. All you need to do is sign this affidavit of Scrivener's error. Are you taking the position that you are truly the buyer and the seller? She wasn't, she was not making an unequivocal statement where she was repudiating the assignment. She was not revoking that assignment. So what we have is, the late payments. We have the issues with the.
We talked about this earlier. It's not a late payment.
My
You
client.
just acknowledged 2 minutes or 10 minutes ago that it was not a late payment.
I did not, Your Honor, respectfully, I don't think I said that. What I said was we did not get the payment. If she made it to Westar, that's a whole different issue. We did not know that at the time, and we sent out the notice saying that she was in.
Correct me if I'm wrong. But you acknowledged a second ago she made the payment to Westar timely. It's just that it wasn't.
I don't know that she made it timely. I don't know that. I don't know that that's a fact in the record. All I know is that my client did not receive a payment. The notices were sent because they were late. Notices were sent to correct the issues with.
Has your counsel been able to find the notice so we can know where in the record it is?
He's still looking. So you have to look at what was going on March 15th. By that time, we had statements from Ms. Asher that she was not going to sign the affidavit of Scrivener's error.
Before the 15th?
Yes, we had.
I'm reading a different record, counsel. Can you tell me where in the record it says before the 15th that Ms. Asher made that comment, that statement, that she was not going to sign?
I believe it's in my client's declaration. I believe my client has it in there. But, at this.
That was said verbally, a verbal statement then? Right. Okay.
But looking after the fact, we had 6 different written communications to Ms. Asher where we said to her, look, we'll turn over possession if you just sign the affidavit of Scrivener's error. We don't trust what you're going to do with this document. On March 21st, March 22nd, March 23rd, March 25th, April 14th, and April 21st. So on 6 separate occasions, we documented in writing. And this is the important fact about the unilateral affidavit of Scrivener's error. Initially, in the initial communications, the affidavit of Scrivener's error was supposed to be signed by both parties. But because she did not sign it, and because we were worried that she was going to go try to sell the property to someone else, we did the unilateral one. But that in no way, shape, or form makes an admission by my client. And the trial court didn't perceive it as an admission because of this document right here, which clearly shows that Ms. Asher was the one, 3 different places, it shows that Ms. Asher was the one that took the assignment to the recorder and recorded it. Right on the right top-hand corner, in the middle, and on the bottom. So I don't. So the trial court looked at that, and that's the undisputed evidence. That was the only evidence at the time when the document was recorded.
That meant that that she unequivocally was not going to perform the agreement. Means she was not going to pay the down payment. She was not going to make the payments for over a year.
Let's look at what she said in the three separate.
I would appreciate if you answered the judge's
But is that what it means? You're telling us to accept that means as a matter of law, that's unequivocally. No reasonable juror could find otherwise.
Well, I can answer that question by reading to you exactly what...
Not what the trial court said,
no.
but
I can read to you, I can answer that question by reading what Ms. Asher said in 3 separate legal proceedings outside...
We're talking about prior to March 15th. I'm focused on prior to March 15th because I see that as the key date here. What happened prior to the time when your client was legally obligated to deliver possession of the property at midnight on March 15th?
Well, respectfully, Your Honor, I disagree with you that March 15th is the operative date because, number one, there's no time is of the essence with respect to my client. Okay. And number two, there's no default provisions in the contract that say if my client doesn't deliver possession, what has to happen.
So what's the implication from that?
But again, what do we have at the time? We have an affidavit of Scrivener's error, or excuse me, an assignment of rights that's been recorded, and so my client was fearful that yes, she wasn't going to make the payments. That yes, she was going to try to sell the property to somebody else.
Prior to the 15th, she was fearful of all those things.
Yes, and that was communicated to the appellant. But you know, looking after that date, look what the defendant did, or look what the appellant did. She files an eviction lawsuit against my client. In the eviction lawsuit, she says at page 11, line 7 of that transcript, so currently I hold the seller's rights to the contract. On page 17, she assigned her rights to me. Right there, she's unequivocally saying, I own this property. I own this contract. This is my house. This, on April 16th, during the she filed a separate breach of contract lawsuit against my client in small claims court. We filed a motion to dismiss, and in response to the motion to dismiss, she says very clearly, and this is Exhibit Q to the declaration of my client, I have no legal obligation to sign the affidavit of Scrivener's error. And that would have been the document that communicated that she was retracting the rescission. But she never did that until after the lawsuit was filed. She also says in that same brief, I currently legally have the rights of the seller based on the assignment of right. Well, what is that statement saying? If not, I'm not going to make the payments. If I can go sell a property because I'm the seller. She then says she files a separate injunction against harassment against my client when she realized that the eviction proceeding was ineffective to get my client out of the property because there was an issue over title. Because all she had to do was sign that affidavit of Scrivener's error and she would have gotten possession. But she didn't do that.
Is that what the Justice Court said?
No, he didn't get into that. They just said there was a title issue. So it was a Justice Court on eviction cases. Once there's a title issue raised, that's it. They have to either transfer the case to the Superior Court or the case gets dismissed. And I think at the end of the transcript, the court actually said it would have to transfer to the Superior Court. For some reason or another, it was never transferred to the Superior Court. And the case ultimately just got dismissed. So the third case, that injunction against harassment case, she clearly says on page 10, lines 1 through 3 of the transcript, Nancy signed a document that actually assigns the seller's rights to me. And when she lost all 3 of these cases, and then she appealed the injunction against harassment case. And even the appellate court in the injunction against harassment case says the decision shows that that appellant argued that Nancy assigned the seller's rights to me.
Understood. And she made these incriminating statements about what she believed this document did. But what is the legal impact and what is the case authority that says if you make statements, but then you don't live up to those statements, you do nothing in reliance on those statements? Because I think even in your briefing you admit you concede that she could have done this, she could have done this, she could have tried to sell the property, she could have stopped paying, but she didn't. So what's the legal authority to say, as a matter of law, again, as a matter of law, she That was an anticipatory breach.
So if you look at the United Cal Bank versus Prudential Insurance Company, that's an anticipatory repudiation case. And in that case, it said if one party unequivocally indicates that he will not perform when the date arrives, an anticipatory breach is committed. In that case, what happened is the trial court did find that the defendant anticipatorily repudiated the contract, and the Court of Appeals affirmed when the lender attempted to add terms to a loan that were not in the original contract. The court held that the insistence by one party upon terms not contained in the contract constitute an anticipatory repudiation. In our case, by taking the assignment and stating in 3 separate court proceedings that she was the seller and had rights as the seller, and by recording that document, telling all the world that I am the seller, she was trying to insist that there were terms in the contract that did not exist. She
also kept making payments, counsel. So how, to me, that seems to be unequivocal, and it has to be, as you know, an unequivocal manifestation of not to render the promised performance.
Well,
so
that's okay.
At very
so making
best,
the payments.
Hold on, let me please finish.
Sorry, Your Honor.
It seems to be equivocal to me because, even granted the statements that she made, she kept making the payments. So there seems to be an equivocation as to going forward with the contract. So disabuse me of that.
Okay, well, Your Honor, she making the payments is not a statement to my client saying, I'm going to continue to honor the contract. I'm not going to treat you as as having no rights. She never communicated that to my client. She never said to my client, no, I'm still going to honor the contract and treat you as the seller. That would have been the unequivocal statement, but she never did that.
But you're flipping the burden. It's not an unequivocal statement that I will continue to honor. It's an unequivocal statement that I won't.
I'm flipping it because we had the unequivocal statements already.
Issue of fact here.
Your Honor, there's no issue of fact. Okay. She's changing contract terms by using that assignment as a matter of law.
Is different because they were trying to add terms that weren't in a written document. You guys, your parties, your clients, entered into a written document. One party recorded it, says this gives me rights, but then does something completely inconsistent with that. So how's a superior court supposed to say, as a matter of law, there's no factual issue here?
Because the court looked at the unequivocal statements that she made. In those 3 court proceedings, the trial court said that.
All of which occurred after, you'd agree, way after March 15th.
Not correct? Way after, days after. Days after.
Okay.
Okay, we're talking. We're not. Okay. This is a 2-month window period of time.
And then she signed the affidavit of scrivener's error
only after we filed the lawsuit and warned her that we were going to rescind the contract. And she was represented by counsel.
And you were able to get $16,000 for those 2 months. That's what the $16,000 comes from. That
was the trespass. Okay, so. We're kind of mixing facts here. So on 3 separate occasions,
all related.
Yeah, on 3 separate occasions, she tried to use self-help means to take possession of the property. The first 2 times, those efforts were thwarted. The 3rd time, she does it on a Saturday. She takes the assignment to the police and says, "Help me get into this house." She changes the locks. She breaks into the house. So from August 2016 until the trial court ruled in our favor. That's what that $16,500 is.
Later on.
Yeah, it's from the date that she can't deny those facts, and just because it's like one of those, it's the proverbial one wrong does not make a right. Even if my client were in the wrong by saying that she committed anticipatory repudiation and filing the lawsuit, that does not give her the right to use self-help means to take the law into her own hands.
But even,
and they don't appeal that issue.
Even if there's a question of fact as to whether your client should have delivered possession by the 15th of March, you're saying that has no impact on
absolutely not, because you cannot use self-help means. What law can they point to?
It seems to me like you're ignoring the law that says when one party breaches.
Okay. If
I'm asking you to assume that there was a breach, a question of fact. So
what do you have to do under eviction law? What do you have to do? You don't just go in a residential context. The law prohibits you.
I'm talking about anticipatory repudiation.
No, I know. I know.
Trespass.
I know. What you're saying is, if we were wrong on the anticipatory repudiation, what rights does she have to obtain possession of the property? She has to go through the legal procedures. She has to file an eviction lawsuit. She has to get an eviction judgment. She has to get a writ of restitution. These are the proper procedures by statute that she needed to follow that she didn't follow. She has not.
I'm not sure of any of that because I don't know if we have any case law about agreements for sale and eviction proceedings, but perhaps we do. But
it would be the same situation like what we saw during the recession. banks, when they foreclosed the property, they could not just change the locks on the owners of the property, or if there was a tenant in the property. They had to go through the proper legal channels. They had to file eviction lawsuits. There's tons of cases in that context. You cannot, there's not a single case, whether it's an agreement for sale, whether it's a deed of trust foreclosure, whatever it is, there is not a single case that says you have the right to take self-help means in a residential context, break the locks, and enter the property. So they didn't cite to a single case or a single statutory authority that would give them that ability. They're not even arguing that in their appeal briefs. It's the first time they argued today that the trespass judgment should be set aside. They did not argue that in any of their briefs.
It struck me as odd that the minute entry doesn't discuss it at all. And the briefing is, at the trial court, was relatively sparse on it. And then the judgment adds this trespass claim. In other words, it didn't seem that there had been a grant after reading the minute entry, a summary judgment on the trespass claim, but the judgment does do that.
I thought it was in there towards the tail end, but again, she grants summary judgment.
Granted, there's discussions of self-help remedies, but there's no discussion at all as to damages. It's completely silent.
Well, it's in the motion for summary judgment. It's laid out pretty clear, and the judge,
the amount, including the amounts in your summary judgment,
and the judge granted that based upon the amounts that were in the statement of facts, and it all stems from the reasonable rental value of the property from the August date that she broke into the property through the date that the court issued its order that said that we were back entitled to possession.
Can you explain that in your brief time? What rental value? What your client was still receiving payments? Is there a reasonable rental value
from August?
Yeah. Your client was being paid for the purchase of the house.
That is true. I concede that. So.
Okay.
I'm running out of time here, but I do want to focus on one thing. All of this is irrelevant. We filed the notice of forfeiture. And any rights that she would have are forfeited under the contract and by statute. So this whole appeal is a complete waste of time, because even if she wins, what's going to happen is we're going to file a motion for summary judgment if she tries to go back to the trial court. The notice of forfeiture controls. Her contract rights have been eliminated because she hasn't made a payment since she's been in here. She has not tried to preserve the status quo. She says she has contractual rights still. They're not existent anymore. So the best case scenario that she can hope for is we go back to the trial court, I file a motion for summary judgment on the notice of forfeiture issue, we win that, and we get our attorney's fees. And we get to keep every penny that was paid under the notice of forfeiture statutes. Again, Your Honors, we believe this entire appeal has been futile. But even if it's not, we believe that the motion for summary judgment was properly granted. And even if the court finds that the anticipatory repudiation is a question of fact, there can be no question of fact on the implied covenant of good faith and fair dealing. All of her actions deprive my client of, initially of title, of important contractual provisions, potentially of payments, and of possession of the property. So she cannot... even if the court finds there's a factual issue on that, there can be no dispute that the trial court properly granted summary judgment on that issue. And my time is way up, but I appreciate the court's time, and thank you.
Thank you. Counsel?
Thank you, Judge. I'd like to very briefly address the breach of implied covenant claim first, and then address the motion to dismiss. The big problem, among others, with the breach of implied covenant holding from the trial court was that it requires proof of damage and causation. The trial court needed to establish as a matter of law that my client did something that denied a benefit to the seller of the property. There's no evidence of that. Yeah, exactly, a benefit of the contract. And there was no evidence of that. In fact, she got more than the benefit of her bargain. Not only did she get all of the payments to which she was entitled under the contract, she also kept possession. So she was denied nothing by my client through this matter.
What about her attempts to break in? Wouldn't that be considered bad faith?
It is a completely separate issue with respect to the contract issues before the trial court, and I think it's not relevant to whether there was an anticipatory repudiation or a breach of implied covenant. If my client was engaged in self-help, there were separate remedies available for the seller to address that issue, but it doesn't excuse the breach by the seller that occurred 4 or 5 months prior to that. And what we hear, and this is consistent with the briefing, is that Ms. Spencer was worried that my client may not pay, that we didn't trust what she was going to do with this assignment document. It's all forward-looking. It's all speculative. There is, again, no definitive statement that my client wasn't going to perform. In fact, her actions are consistent with further performance. We do acknowledge she stated that in a justice court proceeding that she owns the house. Well, of course she owns the house. You know, she's the buyer of the contract. She has certain rights to the property at that time. She also, appellee's counsel quoted a statement attributable to her that said, "Nancy signed the document that signed the rights to me." That is a true statement. The assignment exists. We're not denying that. What we're stating is that, at best, there was a factual dispute about what the parties intended through that assignment. But ultimately, the facts prove that my client did nothing with respect to that document. She didn't stop paying. If she stopped paying, I would see the trial court's point, but she didn't. She didn't rely on that document. In fact, neither party did.
Why didn't your client sign the scrivener's error earlier? At least, I'm not talking about...
Right.
But in the record, what can you point to say that she didn't have the bad faith?
She was threatened, Judge, at that time. And the record reveals that the seller was represented by counsel even before the contract was signed, but the negotiations were between the parties. But very shortly after, the seller refused to give possession. The seller's attorney got involved in the dispute, and he began making threats to, threatening, "You need to do this. You need to sign this document, or else my client's not going to move out of the property." The scrivener's error document to a layperson wouldn't seem like a reasonable document to sign. In fact, even to an attorney, a scrivener's affidavit of scrivener's error seems like an unlikely document to address an assignment. And so my client at the time said, "Wait a second, I don't know what I'm going to do here." She very shortly thereafter, when the lawsuit was filed, retained counsel, and then they made the decision, okay, we should sign this affidavit of scrivener's error. But ultimately, the document was irrelevant. It was in existence for, between March and May, and nothing happened. Nobody took any action in reliance on that document. And so, but to answer Your Honor's question directly, she was not represented by counsel at the time when the initial demands were made upon her after the seller failed to give possession. And so she didn't feel like she was in a place to sign that until she got counsel. And then when she got counsel, she did sign it. Now, if I can very briefly address the motion to dismiss, there's really two reasons it should be denied. The first is that it was untimely. They purportedly completed the forfeiture proceedings on February 16th of 2018. Ms. ASHER's opening brief was due on the 28th of February. They certainly had ample time to file it following forfeiture. They didn't do that. Then they waited an additional 5 weeks after my client's opening brief was filed. Then they filed this motion to dismiss on the very eve of the deadline of their response brief. And under the circumstances, if they felt that the forfeiture proceeding rendered this appeal as moot, they should have immediately moved rather than forcing my client to incur the fees associated with that opening brief. And then not only that, but they waited an additional 5 weeks to unduly delay these proceedings. But more importantly, that motion fails on the merits. The test for mootness is whether a decision of the appellate court would affect the rights of the parties. And I think it's undeniable here that a decision of the appellate court remanding this case back to the trial court level would have a substantial effect on my client. My client paid roughly $100,000 between damages, attorney's fees, statutory damages. And remanding this case would unwind that judgment. It would also allow my client to pursue with her very proper counterclaim for damages. Again, when the seller didn't deliver possession, my client lost out on an existing lease. Again, she was going to lease the property to a third party. Those are damages that she incurred that the trial court just swept under the rug. And I will note finally that the Vinson case is dispositive of that issue. In fact, the facts here are much stronger than Vinson. But Vinson, very briefly, involved a purchaser's efforts to acquire a property through specific performance.
I think you've used all your time.
Okay. Thank you, Judge.
All right. Thank you for your briefs, counsel, and your presentation here today. We do appreciate it. We'll take the matter under advisement and we'll get our order out in due course. We'll now stand at recess and allow the next argument to set up. Thank you.